So those who have attended last time, I hope most of you were participants in the previous one also. So this is a continuation in that series on new labor codes. Now, in this session on challenges and practical strategies for legal practitioners, because I suppose most of audience is LLB students and some practicing advocates, and some of them practicing in labor courts also, and for them it will be very much useful. So the date of implementation is 21st November 2025, and as we know, the 4 new codes that were passed by the Indian Parliament in 2019 and 2020 have been implemented after about 5 years, and 29 labor laws have been now replaced by 4 codes, and there are other labor laws that remain in force, so we shall go into those details also today. And it is going to affect 400 plus, that is because the coverage is going to expand maybe from say 20 crore to 60 crore, and we shall see what are the new categories that are included and definition of wages, worker, employee, because many things have changed. So we are going to see this in more details, and what happens to the existing case law, what happens to the, what are the new challenges and opportunities, particularly for lawyers. So from that viewpoint, we shall see this, what changes it is going to make to law students and to the legal profession. So the legislative framework is that the government of India has consolidated 29 central labor laws into 4 comprehensive labor codes effective from 21st November 2025. The notifications have appeared on the Ministry of Labor and Employment, MOLE. The bare acts are also available as published in the official gazette. They are already available since 2019-20 when they were passed by the Parliament. They are available on India Code website also. So I'm not going into those details, but we shall see the things that are we are going to interpret from that. So firstly, the Code on Wages 2019. It was the first in the series to have been passed. It was done on August 8, 2019, and it replaces 4 laws on wages and bonus. Second one is the Industrial Relations Code, or the IR code we shall call it. So it replaces 3 laws, the 3 older laws. And all the 3 codes, that is IR code, code on social security, that is the SS code, and the OSH code, that is the occupational safety, health and working conditions code 2020. They have come into effect, say on 21st November, but then dated to by the President of India on September 29, 2020. So these are the 4 different codes that are going to that have replaced the 29 laws. So code on wages repeals 4 laws. IR code repeals 3 laws, code on social security repeals 9 laws, and the OSH code, or it is actually OSHWC code, that is, we shall call it OSH code, that is going to replace 13 laws. So there are 29 labor laws that have been repealed. Actually, 2 laws have not yet been repealed, but we shall come to that later. That is the EPF and ESI. They have not been fully repealed, but maybe in 1 year they will be repealed. Now, what are the laws that have been repealed? And what are the sections? So as I have told in my previous session, last week we have seen that it's a good news for law students, particularly LLB students, that their syllabus is reduced to 40% almost. Because instead of, say, about 1204 sections, now they have to study only 480 sections. So what are these codes? Code on wages has now got only 69 sections, no schedules. It replaces payment of wages at 1936, 32 sections. Minimum wages at 1948, that is 38 sections plus 1 schedule. Payment of bonus at 1965, 41 sections plus 4 schedules. And equal remuneration at 1876, that is 18 sections. Similarly, Industrial Relations Code, now it has only 104 sections plus 3 schedules. It replaces the trade unions at 1926, the oldest, one of the oldest acts to be repealed. Another one is of 1923 that we shall see later. So 35 sections it had. Industrial Employment Standing Orders Act 1946, having 15 sections and 1 schedule is repealed. And Industrial Disputes Act 1947, 32 sections plus 5 schedules. So 82 sections plus 5 schedules, that has also been repealed. These 2 codes have come fully into effect, and the 7 laws have been fully repealed. Now, as far as Social Security Code is there, so the laws that it repeals, now the SS code contains 162 sections plus 7 schedules. And it repeals Employees Compensation Act 1923. It is the oldest act to be repealed by this say 4 labor codes. It had 17 sections plus 47 sections plus 4 schedules. There is ESI Act 1948, 139 sections plus 3 schedules. It is not yet fully repealed, but likely to be repealed fully. Few sections are effective to maintain the continuity of benefits. Similarly, EPF Act has not been fully repealed, but likely to be repealed. So EPF, Employees Provident Funds and Miscellaneous Provisions Act 1952, it had say 69 sections plus 4 schedules. Only few sections are remaining now for maintaining the continuity of benefits, except that all the other laws, that is 27 laws, have been fully repealed. And Employment Exchanges Compulsory Notification of Vacancies Act 1959, that is 10 sections. Maternity Benefit Act 1961, 34 sections have been fully repealed. Payment of Gratuity Act 1972, 19 sections has been repealed. Senior Workers Welfare Fund Act 1981, 11 sections have been repealed. And Building and Other Construction Workers Welfare Cess Act 1996, 15 sections that has been repealed. And Unorganized Workers Social Security Act 2008, that is the one of the newest laws to be repealed, containing 17 sections. So except this EPF and ESI, all laws have been fully repealed. Coming to the OSH code, it replaces say 13 different laws. So now it contains only 143 sections plus 3 schedules. So it repeals Factories Act 1948, containing 141 sections plus 3 schedules. Plantations Labor Act 1951, containing 61 sections. Mines Act 1952, containing 98 sections. The Working Journalist and Other News Paper Employees Conditions of Service and Miscellaneous Provisions Act 1955, containing 33 sections plus 1 schedule. And the Working Journalist Fixation of Wages, Rates of Wages Act 1958, containing 15 sections. And the Motor Transport Workers Act 1961, containing 40 sections. These have been completely repealed. And the BD and Cigar Workers Conditions of Employment Act 1966, containing 45 sections. Contract Labor Regulation and Abolition Act 1970, containing 35 sections. Sales Promotion Employees Conditions of Service Act 1976, containing 13 sections. And Interstate Migrant Workmen Regulation of Employment and Conditions of Service Act 1979, having 36 sections plus 1 schedule, have been repealed. Cine Workers and Cinema Theatre Workers Act 1981, containing 26 sections. And Dock Workers Safety, Health and Welfare Act 1986, containing 35 sections. Building and Other Construction Workers, the Regulation of Employment and Conditions of Service Act 1996, 15 sections. So as far as the counting of sections is there, so I have not included only the last section number. I have included all the sections that were inserted through various amendments. And therefore, if you see only the last section, then you might find that the number of sections that I have mentioned here is larger than that, because just as I have stated in my previous webinar, we have seen that CRPC doesn't contain 484 sections. It contains many sections that were inserted through amendments also. Similarly, IPC didn't have 511 sections. It contained many sections that were inserted through amendments. So this count includes all the sections that were inserted through amendments also. As far as the schedules are concerned, so earlier there were 27 schedules. Now there are 13 schedules only. So there is 52% reduction. That means only 40% of sections and 48% of schedules are there. Okay, that was the statistics. Now coming to why these new laws were brought. Why the consolidation? The first, because there are statements of objects and reasons, SOR document that is given to members of parliament for reading when the bills are introduced in the parliament. So in that, first objective is the modernization. That is replace the colonial era laws, that is from 1930s to 1950s. And we know that some laws are existing since 1923, 1926, and many pre-independence legislations. That is more than 75 years after independence. And align with contemporary economic realities, because now there is digital economy, technology, and many different things are there. And meet international labor standards, because India is also a signatory to ILO, International Labour Organization, which is a body of United Nations, and we have some international commitments also, because we are signatory to many international conventions and treaties. Secondly, simplification. So single registration instead of multiple. This we have seen in the last session. that instead of 8 different type of registrations, only one registration is required. One license system, pan India, and now it will be online also. Single return to be filed, so that saves considerable effort and reduce compliance burden as well as harassment and say cost. So these are the advantages. The third one is universalization. So extend the coverage to all workers. We have seen last time that it is extended to gig and platform workers also. So gig workers, platform workers, and aggregators have been included in this. So include gig and platform workers. We have seen the examples that these include people who are working for, say, Flipkart, Amazon, people who are bringing goods to our doorstep, Zomato, Swiggy, and Ola, Uber. So all the workers like gig and platform workers are like, say, Fiverr, Upwork, who are working in India for international clients, like some software professionals and lawyers do. They are all included within gig and platform workers. So they will also be extended as social security benefits. Cover the unorganized sector workers and standardized definitions across laws. Many definitions have been standardized, and we shall see it one by one when we go further into advanced topics this time. Enhance worker welfare. So enhance minimum wages for all. So there will be national floor wage concept that will be fixed by central government. State government can pay higher than that, but not lower than that. Universal social security will be there. Just like in USA, they have social security number that is assigned to child at birth, and it remains with that throughout life. So we already have Aadhaar system in India, but now social security benefits will also be extended. And improved safety standards, because earlier there was only Factories Act. So now Factories Act has been repealed and there are improved safety standards, particularly women safety also, and gender equality provisions. So not only women, but transgenders have also been included, and women are permitted to work in night shifts also. Now we see what are the major challenges when we are migrating or transitioning from, say, older acts to new acts. What are the challenges and opportunities, particularly for law students and for advocates practicing lawyers? So we shall see the major challenge areas are ongoing cases and proceedings. What happens to them? What happens to case law? So if we see the repeal sections, we know there are the last section in any act is repeal and saving. Repeal means what are the older acts that have been repealed. Saving means what happens to the pending court cases. That is mentioned in the saving clause. So we see that cases filed under old laws, they will go as per the old laws. Appeals pending before various authorities. There is complete appellate structure also, and there are some changes also that we shall see further in the penalties and appeals in this webinar. Execution proceedings in progress. These will not be affected. They will go as per old laws. And fresh cases post implementation. So these are the, say, 4 categories in which we have to see this. Firstly, when we see the applicability of existing notifications. So central government notifications, because subordinate legislation will continue. Okay. Only the acts have been repealed, not the rules, regulations, notifications, government orders, and office orders. So they will continue to be effective until they are expressly repealed. And the repeal has already started. So we shall see what are the developments in last 1 month, because after 21st November, it is almost more than 1 month. The state government notification, they continue to be effective. State governments have also notified roles. We shall see progress in different states. Standing orders issued under old laws, they will continue until they have been modified. Industry specific exemptions, they will also continue. Some other industrial laws will also continue, that we shall see separately in this presentation. Now the interpretation challenges are, firstly, legislative intent versus literal meaning. Court normally goes by the literal meaning, but if something is not clear by that, they sometimes go into SOR, that is statement of objects and reasons. So we have to study that also, and then we may even go into the parliamentary debates. Harmonious construction issues. What is harmonious construction? It is a rule of interpretation. It is also called the golden rule. If one law, one statute says this, another or that. So in that, you have to interpret the meaning. कानून का अर्थघटन ऐसे करना है कि ना इसका वायोलेशन हो ना उसका वायोलेशन हो. So you have to obey the both. That is called the golden rule or the harmonious construction. That is in cases of conflict, you have to interpret the law in such a way that there is harmonious construction and both the laws are obeyed. Then gaps in transitional provisions. So there could be some good gaps, and we shall see general versus special laws also in more detail today. Conflicting interpretations. These could be because of different states, different courts, different high courts, different benches of Supreme Court. So these results into different conflicting interpretations. These are the challenges where advocates are required. Then the state-wise variations. So different implementation dates are there because it's a concurrent subject under the Constitution of India, Samavarti Suchi, list 3, under 7th schedule of the Constitution. Most of the state governments have also notified their laws, and there could be different implementation dates, as well as within the act also there could be different implementation, dates varying from state to state. Varying rules and thresholds could also be there because the state government also has different powers. So for that, you have to go to your, the state in which you are practicing, go to their website, Ministry of Labor or Ministry of Labor and Employment, and there you'll have to find out the rules applicable to your state. State-specific exemptions, this could differ. And concurrent, jurisdiction issues could also be there. That is, there could be some conflict between state and center. So at that time, the matter goes to court, and then there is opportunity for advocates. Now the legal framework. So what are the transitional provisions? That is, it has already taken 5-6 years, and now it is likely to take 1 year further because EPF and ESI are still continuing. So if we read the Code on Wages 2019, so section 55 is about repeal and savings. It says that all repealed laws continue for pending matters, that is the sub judice matters. Rights, privileges, obligations have been preserved that have been accrued under the older acts, and proceedings may continue under old law. Secondly, the IR Code 2020, section 102 is about repeal and savings provision. So it says that existing standing orders remain valid until they have been repealed or superseded by the new laws, and registered trade unions continue until their registration expires or it is renewed, then it will be under new law. And pending disputes are not affected. Coming to the third one, Code on Social Security 2020, section 164 says about repeal and savings. So existing social security schemes continue, and there are contributions and benefits have been protected, as we have seen, because EPF and ESI have not yet been fully repealed. So transition is likely to take 1 more year, and tribunal proceedings have been preserved if matters are already proceeding before the industrial tribunals. Coming to the OSH code, section 141 is about repeal and savings. So it says that licenses issued under old laws are valid for unexpired period, and once they are expired or they are renewed, then that will be under the new law, so that there is no sudden rush, because of coming into existence these laws overnight. Actually, it's not overnight, as we know, it took 5 to 6 years. Factory registrations continue, and safety committees constituted under the old laws, so they remain constituted. Now the key principle is that accrued rights are protected and pending proceedings continue. This is as per the General Process Act 1897, which is taught in the interpretation of statutes paper in the LLB courses. So I hope most of the participants are aware of this. Now the status of ongoing cases. That is the detailed analysis. First, we see the cases filed before the implementation date, that is before 21st November 2025. Firstly, the labor court cases. We have classified it into 4 categories: labor court, industrial tribunal, high court, and Supreme Court. So what happens to labor court cases? So continue under the law under which they have been filed. So as per the old laws, they will continue. No need to amend the pleadings. They are governed by the repealed law provisions, and final orders are executable under the new code. So as far as the execution decree is there or execution of the laws is there, that will take place under the new code after the final decision, because there are execution proceedings also. Secondly, the industrial tribunal proceedings. What happens to them? So Industrial Disputes Act 1947 continues to apply for them, and reference orders remain valid if the matters have been referred by lower courts to the higher courts, and awards can be challenged under new code. So if the awards are there and they have to be challenged, then they can be challenged under new code. That is an option, and there are different options for employers and employees that we shall see subsequently. And execution can be through will be through new machinery, because new machinery has come into effect for repeal for appeal provisions that we shall see today. Thirdly, what happens to the high court matters? So writ petitions continue on same grounds. Constitutional challenges are unaffected, and reference to new provisions may be required for relief, because if the parliament has implemented that, then the courts may also be liberal to grant those benefits or say accept that by their power under case law. So the case law is in alignment with the new laws. The courts may do that. And appeals from tribunals are governed by the new code. because they are appeals. So once the appeals have been say completed at tribunal level, then in High Court they will be under the new code. As far as Supreme Court appeals are there, so they will continue on merits under the old law. Interpretation may reference the new provisions, because as I told you, it is the liberty of the courts, and they may take into consideration that the Parliament has passed the new laws, and they might say prefer the case law or the new cases, so that it is in alignment with the new statutes. So that is possible. The courts can do that and remand the matters governed by applicable law at trial stage. So because they can even remand those to the lower courts, that power is there. Now, what happens to the fresh cases? That is, it is more than 1 month now that have come into effect, the 4 courts. And after 21st November 2025, so fresh cases must be filed under new courts. New definitions apply. We shall see what are the new definitions. New thresholds and jurisdictions, and new limitation periods we have specified. Because limitations have also been specified there. Within what time you can challenge or you can file say appeals against the orders, final orders. And there are new thresholds and jurisdictions that we shall see. Now the practical strategies for ongoing cases. Firstly, for defense or management, who are say defendants in labor court cases. Firstly, the strategy one is the jurisdictional challenges. That is, check if say the situation, that is the threshold, has changed under new code. The thresholds have changed, like in case of say gratuity 5 years, it has become 1 year. Instead of 100 employees, there are 300 employees in some cases. So these are the threshold values that we are talking about. Examine if say establishment is still covered. Thirdly, verify the authority competence under new law, because that has might have also changed in some cases. And raise preliminary objections if jurisdiction is affected. Because if you are going to challenge jurisdiction of a particular court, you have to do as early as possible, and if possible within the first hearing itself. Otherwise, at later stage, once you lose the case, then you can't challenge the jurisdiction. So we have to remember that if you are going to challenge jurisdiction, do it at the earliest possible stage. Second strategy is limitation issues. Limitation is to contain the cases going to court. So law of limitation and limitation at 1963 is there. Plus there are many special limitations also in so many different special laws. So calculate the limitation under the law applicable when cause of action arises. So we have to see whether when the cause of action arose and whether it is continuing cause of action. Secondly, the benefit of longer, in Hindi we call it vaad ka karan. So cause of action, vaad ka karan kab arise hua, that we have to see. Then benefit of longer period, if new code say extend the time. So is there something new benefit under the new laws? Then that may be perhaps availed with the permission of the court if courts allow that. And savings clause protects the applications filed within time under old law. So we have to see the saving clause also that we have already seen under the 4 new codes. Third strategy is procedural compliance. That is, file the responses or appeals as per old procedure for pending cases, because for them the old say statutes continue. Otherwise, it would be too old, too late later. Then use new forms only for fresh proceedings, because the forms will also have also been changed in many cases, and these are going to be prescribed by the state government. So there could be new forms also. Then we see that maintain the dual compliance during transition. That means we have to comply with the older as well as the newer laws. Now, for claimants or workers who are the parties to the cases, so for them, the first strategy is protect the accrued rights. That means what were the benefits given to them under the older laws. So file claims before limitation expires under either law, so that they will be safe from both sides under the older as well as the newer laws, newer codes. And cite the savings provisions to protect substantive rights. So at that time, they can argue that older laws were applicable, and rely on beneficial provisions of new code were applicable, because the courts might grant them, or even the statutes may permit them. Strategy 2 is the strategic timing. That is, compare the benefits under old versus new law. It not only wages, it could be anything. So all benefits have to be considered. Then file under the more beneficial regime if your laws will be beneficial to you or the older laws. And there the advocates could be of great help to the litigants. And consider staggered claims if multiple causes of action are there, so that even if one cause or a few causes of action fail, then your petitions may be granted. Strategy 3 is the amendment applications. So whenever you are filing amendment, so at that time, these are the things to be taken into consideration that may seek to amend pleadings to include new code provisions. So you may, with the permission of the court, amend your pending applications, demonstrate how new provisions say strengthen your case, and courts generally allow amendments in interest of justice. So it depends on courts. Coming to the applicability of existing notifications and rules, this is very important part of this presentation. So it is not the case that all the older laws have been repealed. So what happens to the other laws outside labor code we are talking now, outside the four codes? So what are the other laws that remain and what happens to them? Firstly, the minimum wages notifications. So old notifications continue till revised under new code. Action required is monitor for new wage schedule under the code on wages, because these are notified by the DLC, Deputy Labor Commissioner of your state, or there could be central or state. In central, it is called CLC, Central Labor Commissioner. Legal basis. So savings clause preserves the existing notifications, and transition period is typically 6 to 12 months for revision. Secondly, the exemption notifications are there. So the status is they remain valid unless expressly repealed, explicitly revoked. So you have to watch for that. The MOL, that is Ministry of Labor and Employment website. So examples are like Factories Act exemptions for seasonal factories, Contract Labor Act exemptions if they are, and standing order exemptions for certain establishments. So validity is until corresponding state rules specify otherwise. So in this case, you have to go to the state rules also and see your state government website or Ministry of Labor or Department of Labor. Now, industry specific orders. So BD industry, existing rules under BD Workers Act continue. Plantations, specific notifications remain in force. Constructions, so BOCW rules are applicable in till the new OSH rules specify. So building and other construction workers rules remain in force. Mines, safety regulations continue under the savings provisions. So these are industry specific. Coming to the state government rules. So status as on December 2025 is states with full rules established published are 28 states and union territories. States with partial rules are 2 states. Pending rules, some states are there. Nagaland has not complied, so wages code is still pending. But now that the central government has notified, so they will have to fall in line. And key state-wise issues are different thresholds for applicability could be there, because it is a concurrent subject under the constitution. Varying implementation dates for specific provisions that could be there, and state-specific exemptions and relaxations could be there. It depends on state government, and differential treatment of establishments that could also be there. It is not in violation of Article 14 and 16. Government can do that. Complete implementation, that is all 4 codes rules published. They are published in case of Andhra Pradesh, Arunachal Pradesh, Assam, Bihar, Chhattisgarh, Goa, Gujarat, Haryana, Himachal Pradesh, Nagaland, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Manipur, Meghalaya, Mizoram, Odisha, Punjab, Rajasthan, Sikkim, Tamil Nadu. Social security is still pending in Tamil Nadu. Telangana, Tripura, Uttar Pradesh, Uttarakhand. As far as UTs, union territories are there, Chandigarh, Jammu and Kashmir, Ladakh and Puducherry. So we can see that almost all states have published the 4 codes, that is rules under the 4 codes, where they have rule making powers under the codes. State-wise implementation status is such that partial implementation in case of Delhi. So wages code plus social security and IR and OSH are pending. Actually, central government has to do that as per the parliament, but there is assembly also. Nagaland, so OSH and social security only. So they have implemented only 1, and 2 are pending, that is wages and IR. So 2 codes are pending in Delhi, 2 codes are pending in Nagaland. West Bengal, no rules published for any code. Completely, we can say not implemented all these 4 laws, but the central has notified. So the state government will also have to do that. Otherwise, it could result into center-state conflict, as you know, and the matter may go to Supreme Court. Andaman and Nicobar, so all 4 codes have been implemented. Now the key observations are most states aligned implementations until with 21st November 2025. Some states published rules earlier, that is 21-24, because 4 years have already passed, but deferred the enforcement because the central government itself had not done that. And West Bengal remains the significant exception, as we have seen here. Coming to the critical differences state-wise. So threshold variations could be there. For example, code on wages. So Maharashtra, specific provisions for shops and commercial establishments. Gujarat, that is post 16 December 2025. So they have enhanced the flexibility for women workers, that is right status. Haryana modified the overtime provisions. Industrial Relations Code, so threshold on standing orders, generally 300 workers. Some states have proposed 100. Prior permission for loyalty retrenchment, so 300 workers threshold. So that has been increased from 100. And strike notice period, it should be minimum 14 days notice as per the new IR code. So uniform for 14 days, but state rules vary on say procedural details. Coming to the social security, so ESIC coverage, Employee State Insurance Corporation. So wage ceiling is rupees 21,000 per month. It is uniform as per center rules. Voluntary coverage, so states differ on procedures for less than 10 worker establishments. Implementation is phased approach, varies by state. Coming to the EPF coverage, Employees Provident Fund. So threshold is 20 workers uniform as per the Central Act. Wage ceiling is rupees 15,000 per month. State exemptions, so some states have granted temporary exemptions for specific sectors. Coming to the OSH, Occupational Safety and Hazard and Working Conditions Code. So factory definition, we have seen that it is modified. Earlier it was 20 without power, 10 with power, that is electrical power. So with power, now it is 20 workers threshold uniform across India. Without power, say 40 workers threshold uniform. As we know, the state government can't override the central provisions. State relaxations are, some states have granted exemptions for MSMEs. Working hours, so standard is 8 to 12 hours per day, 48 hours per week. And overtime is double wages, mandatory. So it is uniform. State variations have different provisions for women working at night. So there the provisions are different at present under the OSH code. Coming to the other acts. What are the other acts besides the 29 laws that have been repealed or 27 laws that have been fully repealed? So we see what are the older laws that continue and what are the things that they cover under the labor laws, because that could also be in your syllabus for students as well as practicing advocates. So firstly, the Apprentices Act 1961, it remains in force. Legal implementation post code is that it is expressly kept outside the labor codes because apprentices are not treated as workers or employees under the codes. They don't fall within this definition of worker or employees. Engagement, stipend, termination, and obligations remain exclusively governed by this Apprentices Act. And orders cannot be invoked for say PF, gratuity, or say IR disputes or OSH issues of say apprentices unless separately notified. So this act remains in force. Secondly, the Bonded Labor System Abolition Act 1976. Status is that it remains in force. It's a penal constitutional statute implementing Articles 21 and 23 of the Constitution. It operates independently of labor codes, and since Constitution is above, that remains in force. Labor codes do not dilute or override the offences, vigilance mechanisms, or rehabilitation obligations. The third law that remains in force is Child Labor Prohibition and Regulation Act 1986. It remains in force as amended in 2016. Legal implications are that it continues as a special law covering prohibition and regulation of child labor. As per the interpretation of statutes, all the law students and advocates know that special law overrides the general law, and the 4 labor codes are general law. General law like the CPC, like the CRPC, or like the BNSS. And therefore, the special law always overrides the general law. But if something is not clear in the general law, that is the labor codes, then you have to refer to the special codes. This is as per the settled law and as per the principles of interpretation under the interpretation of statutes. So labor codes supplement but do not replace this act. And in case of conflict, child protection law prevails. 23. It remains in force. Legal implications are it is independent criminal statute. It is unaffected by labor codes, continues to apply to guardians, employers, and intermediaries. The 5th law is child and adolescent labor. Actually, it is a renamed act. So these adolescent labor words have been added in 2016. So now it is Child and Adolescent Labor Prohibition and Regulation Act 1986. It is in force, not repealed. Effect after labor codes is that, say, it operates independently outside the, it overrides the labor codes in case of conflict because it is a special law. And stricter, say, child protection regime continues unabated. So as amended in 2016, the status is that it is in force. It is not repealed by any of the 4 labor codes and continues to apply even after 21st November 2025. Now, what has changed in that amendment? As we know, the word adolescent labor, adolescent means here we are talking of 15 to 18, or 14 to 18 children. So the Act now absolutely prohibits child labor, that is below 14 years, except limited family, enterprises and artistic work. It regulates the adolescent labor, that is 14 to 18, Kishore Vay, 14 to 18 years, with a complete ban in hazardous occupation and processes. These have been mentioned there in Employees Compensation Act. There were two schedules, that is the dangerous industries, Schedule 1, Schedule 2, where child labor is completely prohibited, and where say below 15 are prohibited. So now child and adolescent are now statutorily distinct categories. So for them, this act applies. Then legal implications after implementation of labor codes, that is this Child and Adolescent Labor Act of 1986, as amended in 2016, it is independent and overriding special statute. This act is a child rights and penal legislation, not merely a labor regulation law. And the labor codes do not repeal or dilute or override it. As far as the interaction with OSH code, because there could be some overlaps. So the Occupational Safety, Health and Working Conditions Code 2020 also restricts employment of adolescents in hazardous work. Because that was there earlier in the Employees Compensation Act, which was earlier Workmen's Compensation Act of 1923. So, however, in case of overlap or inconsistency, the Child and Adolescent Labor Act prevails, being a special and stricter law as per the interpretation of statutes. And the penal consequences are unaffected. That is, enhanced penalties introduced in 2016, including imprisonment and fines, remain fully enforceable, and prosecution can be launched independently of any action under labor codes. There is no employee or worker shield. So employees cannot take shelter under the labor codes, that is the code definitions of worker or employee. And engagement of a child or adolescent in violation of this act is per se illegal, regardless of the code compliance, whether even if you are complying with the 4 labor codes. So this is independent law that is written. Constitutional underpinning is that it continues to say operationalize Articles 21A, new article that was inserted through amendment in the Constitution, 2439E, under directive principles of state policy, and F. Courts consistently treat violations as serious penal social offenses, not procedural lapses. The drafting or litigation tip for lawyers is, in writs, prosecutions or compliance advisories, never cite the pre-2016 name. Use the word adolescent labor also, because that is the new name. So it is often flagged by courts if you cite the old law. Always plead it as a special penal statute, not a labor regulatory law. And when opposing employees' defenses under OSH or Social Security Code, assert special law supremacy, because special law always prevails over the general law, and now the 4 labor codes are the general law. The 5th is the Employers' Liability Act, 1938. So that statute remains in force. Legal implications are it survives alongside the Code on Social Security. It is still relevant on, say, for common law negligence claims, where employee, that is the for law of torts, we can say, where employees' compensation provisions are not invoked, and it can operate parallel to code remedies, subject to, say, remedies, because there could be more than one remedy, civil and criminal, available, as we know. Next is the Fatal Accidents Act. It remains in force, 1855. बहुत पुराना कानून है अंग्रेजों के जमाने का. Legal implications are that continues to govern civil compensation claims by legal heirs for death due to negligence, and labor codes do not bar actions under this act, and frequently invoked alongside, say, tort law and constitutional claims. 7th is the Personal Injuries Compensation Insurance Act 1963. It remains fully in force. Legal implications are insurance-oriented statute. It is not replaced by the 4 labor codes. It may coexist with employees' compensation provisions under the SS, Social Security Code. 8th is the Dock Workers Regulation of Employment Act 1948. It has not been repealed. It remains in force. Legal implications are it continues as a sector-specific, because it is applicable only to dock workers. So it is a special law, special statute. Labor codes apply only where not inconsistent. And dock labor boards remain statutory authority. They retain their statutory authority. 9th is the Coal Mines Provident Fund and Miscellaneous Provisions Act 1948. So it remains in force. Legal implications are that it is not repealed despite Social Security Code, and coal sector continues under its own PF regime until expressly repeal or merger. Maybe they will do something in next 1 year. 18th is labor laws. exemption from furnishing returns and maintaining registers by certain establishments at 1988. It remains in force. Legal implications are that it continues to apply for procedural exemptions. However, many of the objections are now achieved through single register and single return mechanism under the codes. That is the difference. And it operates supplementally, not inconsistently. So there is no inconsistency. It is a supplemental law and therefore it remains in force. Then sexual harassment of workers, POSH Act, at workplace, Prevention, Prohibition and Redressal Act 2013. We call it POSH Act after the Nirbhaya gang rape case. So the POSH Act continues to remain fully in force and are unaffected by the implementation of the 4 new labor codes, because the labor codes do not repeal, subsume or replace the POSH Act. So sexual harassment is indeed a distinct gender justice and human rights issue. It's a civil law rooted in Articles 14, 15 and 21 of the Constitution, and therefore governed by special standalone statute. While the Industrial Relations Code and OSH Code also they address the service conditions of women, discipline, and workplace safety, general sense, because that is the general law. Both these IR code as well as OSH code are the general laws, and all the obligations relating to the constitution of internal committees, that is internal complaints committees, complaint redressal, inquiry procedure, and timelines, confidentiality, and employer duties continue to be governed exclusively by the POSH Act. So POSH Act is not affected by the labor codes. By drafting or advisory tip for advocates and law students is, in case of any overlap, the POSH Act prevails as a special law, and compliance with labor codes cannot be cited as a defense against POSH violations. Secondly, POSH compliance is mandatory irrespective of the code thresholds. And ICC, Internal Complaints Committee, within all organizations, workplace, schools, colleges, universities, district level, state level, national level. So ICC constitution training and annual reporting remain independent statutory duties, and labor codes do not dilute employer liability under the POSH framework. There are second categories of welfare fund and cess laws, industry specific, that remain in force. In the previous webinar, we have seen that fund depends on the number of employees in your industry, and cess depends on the production. आपका उत्पादन कितना है? So based on fund and cess are different, and there are different statutes. They all remain in force. So these acts continue independently because the labor codes do not create substitute welfare fund mechanisms for these sectors. Actually, these are the taxes or duties to be given to the government. We call them funds and cess. So BD Workers Welfare Cess Act 1978-76 remains in force. BD Workers Welfare Fund Act 1976. Senior Workers Welfare Cess Act 1981. It is a welfare fund act that has been repealed. Iron core mines, manganese ore mines and chrome ore mines, because these are found together, these ores. Labor Welfare Cess Act 1976 and Labor Welfare Fund Act 1976. And limestone and dolomite mines, Labor Welfare Fund Act 1972, and mica mines, Labor Welfare Fund Act 1946. These all codes, these all acts remain in force. They have not been repealed. The legal implications for all above are that labor codes do not repeal or override the sector-specific welfare cess or fund statutes. So employer must comply with both as per the rule of harmonious construction, the golden rule. So general labor obligations under the codes and the sectoral welfare contributions under these acts. Coming to the third category, safety and industrial regulation laws. That is the outside the labor codes. Firstly, the Indian Boilers Act 1923, क्योंकि boiler फटने से बहुत खतरनाक accident होते हैं. This statute remains in force. Legal implications, technical safety law. So OSH code does not repeal it and continues to apply concurrently with OSH code licensing and inspection forms. Then Dangerous Machines Regulations Act 1983. It remains in force. Legal implications are continued as a specific machinery safety statute, and OSH code operates in addition, not substitution. So there is no conflict, no inconsistency. Next, the EPA, Bhopal Gas Tragedy के बाद जो बनाया गया था 1986. So it is a statute that remains in force. Mainly, actually, it is an environmental law. So it is a constitutional or environmental framework law. Labor codes cannot dilute experimental health or safety standards under the Environment Protection Act. Next is the Public Liability Insurance Act 1991. It remains in force. Legal implications are strict liability statute for hazardous industries and creates independently of OSH and Social Security codes. The fourth category is other regulatory or allied statutes. So industries, IRDA Act passed by the Jawaharlal Nehru government in 1951. It remains in force. Legal implication is that it governs the industrial licensing and regulation, and labor codes do not encroach on IDRA domain. Don't confuse that with IRDA, which is Insurance Regulatory and Development Authority. So it is different. IDRA is different from IRDA. Immigration Act, people going outside India. So this statute remains in force. Immigration are people coming from outside India to India. That is immigration. Immigration are people going outside. So legal implications are it regulates the overseas employment. Labor codes apply only to domestic employment unless expressly extended. Then Collection of Statistics Act. That is, they have to reply. All the industries are supposed to reply to the Department of Industries for statistical purpose. So it remains in force. Legal implication is it is an administrative or statistical statute, and labor codes neither repeal nor conflict with it. So this reporting remains. Then State Shops and Commercial Establishment Acts are there. So they remain in force, state law. Legal implications are they continue until replaced by state level codes rules. So now it depends on all the state governments whether they want to continue with the old shops and commercial establishment or they want to replace that by new acts. So central labor codes do not automatically repeal the state shops and establishment acts. The sixth is practical litigation takeaways. So labor codes repeal only the 29 specified central acts as the implied repeal. They do not affect this say previous 25 statutes that we have seen out of the 54 total laws, and special laws prevail over courts in case of conflict. Penal, welfare, environmental, and sector-specific say statutes retain full force. For pleadings, these are the three questions that we should ask. The first question is always occupied by special statute. Special statute, then special law prevails over the general law. Second question is, has an express repeal been notified? Because there should be notification. As we have seen, even under those 29 laws, EPF and ES have not yet been repealed fully. And is the code of provision inconsistent or merely supplemental? So if it is inconsistent, then maybe you can approach the court for resolving the conflicts. If it is supplemental, there is not going to be any conflict. So both remain in force. Now the interpretation challenges, because these are where the advocates are needed. First is the definition of wages. So old law, Payment of Wages Act, it excluded the HRA, conveyance, special allowance. Each law had different definition. Now we have the 50% rule, as we have seen in the previous webinar. So the new code section 2F defines unified definition. And there is 50% cap, that is allowances limited to 50% of total remuneration, which we call as CTC, cost to company. So impact is basic salary, say increases. So basic salary of all workers say increases. It affects the payment of PF, gratuity and bonus calculations. And this is where the advocates come into picture for calculation of these PF, gratuity and bonus benefits. Interpretation issues are, firstly, what constitutes special allowance, how to treat say variable components, and transition of existing wage structures from older to new one. Practical strategies, review all the employment contracts, appointment letters, etc. Restructure the CTC, cost to company where necessary, and issue addendums to the existing contracts, because since the new laws have come into effect, so therefore as per the laws, there could be new addendums to the appointment letters that need to be say issued. Document the reasons for changes. The documentation is necessary so that there is no challenge. Fixed term employment. So under the old law, it was not defined in most labor laws, and it was limited only to certain industries like say apparel or leather, and it was different from contract labor. Under the new code, it is defined across all codes, all the 4 codes. Fixed term employment, FT we shall call it. Equal treatment with permanent employees, and gratuity after 1 year. Previously it was 5 years, and all statutory benefits are applicable to the FT employees also, fixed term employment. Now the interpretation issues that arise are, is every fixed term contract now entitled to gratuity? How to distinguish from casual employment? And what happens to the existing FT agreements? The practical strategy is review all the fixed term employment agreements, ensure compliance with the equal treatment provisions, and budget for gratuity liability after 1 year, and consider impact on hiring strategies. These are the issues for maybe HR departments. Challenge 3 is gig and platform workers, because now we have seen that the benefit has been extended of labor laws from about 20 crore to 60 crore people. So that is a major change. So no legal recognition was there under the old law, not covered under social security, no definition for or framework was there. Now under the new code, social security definitions are under section 2 subsection 35. Gig worker has been defined. Section 2 subsection 62. Platform worker has been defined. We have seen that in last webinar previous. one. Section 2, subsection 5, aggregator defined. Aggregators are like Ola, Uber, Amazon, Flipkart. These are examples of aggregators, or Upwork, Fiverr. So mandatory social security contribution has to be there, 1 to 2% of the turnover. Now the interpretation issues that arise are who say qualifies as aggregator, that is whether they come within the definition of aggregator or not, what is covered under the turnover, which workers are included or excluded, and state specific schemes versus central schemes, because there could be these conflicts also. Practical strategies: assess the business model for aggregator classification, calculate the contribution liability, register platforms as required, because many things are done online also, and for gig and platform workers, and await detailed rules and notifications, because they have started pouring in since last 1 month, and some I have included at the end of this presentation also. The conflict resolution between old laws and new laws. What are the basic principles by which we can be guided? First is the beneficial interpretation. किसमें ज़्यादा फायदा है? So courts adopt interpretation favoring worker welfare. Secondly, where conflict exists, more beneficial provision applies. Thirdly, the constitutional mandate under Article 43, that is DPSP, Directive Principle of State Policy. Principle 2 is the non-obstant clauses, notwithstanding anything contained in any other law for the timing and force. Like this, you might have, these are called non-obstant clauses in Latin, as per the interpretation of statutes. So new codes contain overriding provisions. Section 2 of each code, notwithstanding anything contained in any other law. So watch for this statement if there is this clause at the beginning of the section. And new code prevails over special or local laws. Local laws are, say, maybe state laws, or which are applicable to part region of a state. Third is the harmonious construction, or the golden rule. So attempt to reconcile conflicting provisions, give effect to both if possible. एक एक्ट में ये लिखा है ये करना है, दूसरे एक्ट में लिखा है ये करना है, दोनों में से किसको मानना है? These are the conflicts that arise. So avoid rendering either provision redundant, क्योंकि पार्लियामेंट कोई भी काम बिना मतलब के नहीं करता है. So this is the golden rule, or the harmonious construction rule. Fourth is the purposive interpretation. What is the purpose? So look at the legislative intent. You get it under the SOR, statement of objects and reasons. So that is important. Sometimes courts also go into that in case of conflict, and parliamentary debates may be referenced in some cases. Practical implications for practical application of this is some scenarios we shall see where this conflict resolution applies. First is the gratuity calculation, for example. So conflict is old law. Gratuity was say 15 days multiplied by last drawn wages multiplied by say years of service divided by 26. Under the new code, similar formula, but wages redefined, because of definition of wages, the gratuity calculation will also differ. So all this needs to be recalculated. So 50% cap on allowances. Resolution is that new definition of wages applies. Higher basic salary means higher gratuity, and therefore it is beneficial to workers. And action for lawyers is calculate the gratuity under both definitions, older and new laws, apply higher amount principle, and advise clients on provision. Your clients could be workers or management, okay, or even government, for government lawyers. Secondly, we see retrenchment compensation. So earlier, under the old law, the prior permission required for establishment with 100 plus workers. Now it has been extended to 300 plus. So new code is threshold increased to 300 workers. That means if it is 100 to 299, no government permission needed for retrenchment. So resolution is new provision applies prospectively. भविष्यलक्षी प्रभाव से लागू होता है, भूतलक्षी प्रभाव से लागू नहीं होता है. Okay, so it applies not with retrospective effect but with prospective effects. भविष्य में लागू होता है, that is after 21st November 2025. Establishment is 100 to 300 workers, no prior permission say needed post 21st November 2025. And existing permissions remain valid, and more flexible regime means not necessarily more beneficial to workers. So this resolution needs to be kept in mind. Action for lawyers is advise on the new thresholds, review the existing permissions, counsel your clients on procedural changes, and document the compliance. It is necessary for say due diligence with the law. And legislative intent, what are the key documents that we need to refer to? Parliament ने कानून क्यों बना है? So the sources for interpretation, first is the SOR, statement of objects and reasons, so applicable with each code. Parliamentary committee reports, that is Rajya Sabha, Lok Sabha, available on these parliament websites or sansad.in. Key objectives, so these are simplification, universalization, and say ease of compliance. Then there are parliamentary debates. So Lok Sabha debates 2019-20, Rajya Sabha say discussions, ministers' responses to questions, starred and unstarred, स्टार्ट में मंत्री का रहना जरूरी होता है सदन में, अनस्टार्ट में मंत्री का रहना जरूरी नहीं होता है. सो देयर कुड बी स्टार्ट और अनस्टार्ट क्वेश्चंस अवेलेबल ऑन लोकसभा राज्यसभा वेबसाइट्स. मिनिस्ट्री ऑफ लेबर, that is MOL clarifications. So official FAQs released by ministry, they are available on MOL, Ministry of Labor and Employment website, central government, labor.gov.in. Office memorandums could be there, circulars to state governments, and these are available at labor.gov.in. https:/optional है, वो आप लगाओ तो भी चलता, नहीं लगाओ तो भी चलता है, ब्राउजर समझ लेता है. Press Information Bureau, PIB releases are there. So official government press releases, implementation guidelines are there, interpretation notes are there. These are available on MOL website. EPFO and ESIC circulars, इनकी अपनी websites है. So operational guidelines for social security, contribution circulation calculation methods, coverage say determination, and these are available at epfindia.gov.in and esic.gov.in. So these are the two websites to which you can refer, क्योंकि अगले एक साल इसकी जरूरत पड़ेगी until transition phase. So EPFO and ESIC websites need to be referred. Now the key legislative intent say points. Firstly, from statement of objects and reasons, SOR, that is rationalize and amalgamate the relevant provisions, that is the 29 labor codes, facilitate statutory compliance. So we see that imprisonment change हुआ है, penalty कुछ बढ़ गई है, financial penalties. Extend so there is more deterrent effect. Extend social security to all workers. So these have been increased in many cases. Promote the ease of doing business while protecting worker rights. That is to bring our FDI into India, foreign direct investment, and harmonize definition of wages across laws. Practical use is cite in legal arguments. These are the phrases that we can use in our drafting. Support the purposive interpretation, why these laws have been interpreted or they have come into force. Resolve the ambiguities and demonstrate the legislative purpose in court. Now the adaptation strategy is for legal practitioners. Firstly, for litigators. So case assessment protocol. That is, identify the applicable law, whether it is old or new. Secondly, check the transitional provisions. Compare the remedies under both regimes, older and new, and determine forum and jurisdiction. Second is the pleading strategies. So draft the pleadings dual provisions, both that is cite both old and new laws where applicable. Involve the beneficial interpretation principle and include the saving clause arguments, which generally the last section of the codes. And evidence and documentation. So gather the documents showing compliance under old law, demonstrate the continuity of rights, maintain the complete employment records, and obtain the certified copies of old notifications. Now the code submissions. So for that, prepare the comparative charts, that is old versus new provisions, highlight the legislative intent, and use the ministry clarifications, and cite early case law developments, because there are many High Court and Supreme Court judgments that have been now adopted into the new laws. Then for corporate advisors, compliance audit, that is review all existing employment contracts, assess the wage structure, which is the 50% cap as per the new definition of wages, examine the fixed term employment agreements, and check social security registrations. Policy updates, that is draft new HR policies aligned with the new codes, update the leave policies where necessary, revise the gratuity policies because there is 1 year eligibility, and implement women safety measures, that is night shifts, along with their consent and security. Documentation system. So implement the single registration system because now no separate registrations are required for different laws. Prepare for unified returns. This could be online also. Digitize the employment records, that is necessary in many cases. Sham Suvidha and many portals are there. Maintain state-wise compliance calendar. For training programs, conduct the training for HR issues, HR teams, that could be done by advocates. Educate management on new obligations. It's actually duty of corporates. Educate the management on new obligations. Brief workers on new rights, and create the awareness of compliant mechanisms. For labor law practitioners, that is those who are practicing in labor courts, advisory practice. Firstly, you have to advise, that is due diligence. So develop the expertise in new codes, create ready reckoners for clients, offer the compliance audits, and provide transition planning services because they will be required. They are very much in demand, maybe booming demand for this advocacy profession. Drafting skills. So master the new contract formats, draft standing orders under the new code, prepare the settlement agreements, and create policy documents. So this is where drafting work is needed. Representation. So understand the new tribunal procedures, learn new appeal mechanisms, familiarize with new authorities, and study the revised jurisdiction rules. And there is continuous learning, otherwise we may become obsolete. So follow the ministry notifications, track the state rule amendments on their state websites. There is also study the emerging case law, that is the newer case law will start appearing soon, and attend the critical compliance checklist, what needs to be done. So, intermediate action within 3 months implementation for, say, employers. Firstly, 3 months, 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 3 Obtain the unified legislation under the new registration under the new codes. Apply for Pan India license where applicable. Issue appointment letters to all workers. This is mandatory now. Restructure the wage environment, that is 50% basic minimum. Update employment contracts for fixed term workers. Revise the gratuity policy, that is 1 year eligibility, and implement return safety measures if employing women at night, and register for ESIC or EPF if newly covered, and constitute safety committees for say 500 plus workers, and display statutory notices under the new codes and conduct compliance audit. So that is short term. Coming to the workers or unions, what needs to be done within next 3 months? So verify appointment letters received, check wage restructuring compliance, understand the new grievance mechanism, know rights under the new codes, and register for social security benefits, and verify say FT, fixed term employment benefits if applicable. For medium term actions, that is what needs to be done within next 3 to 6 months for employers. File the unified annual returns, revise the standing orders if applicable, implement the new working our schedules, establish internal compliance committees for women's safety, train the supervisors on new compliance requirements. There is update the payroll systems, because that software may also need to be changed, create the digital employment records, and review and renew licenses under the new regime. For legal practitioners, what needs to be done over next 3 to 6 months? Update the legal databases with new provisions, develop template agreements and policies, create comparison alert charts for client advisories, and establish say network with labor department officials, and prepare FAQs for clients along with answers, and organize the training sessions. What needs to be done long term? That is 6 to 12 months, because then the even EPF and ESIC will be fully repealed, and older two laws will also be repealed, and new that is the fourth code will also come into force fully. So strategic compliance is assess the impact on business operations, optimize the workforce structure, budget for say increase social security contributions, plan for fixed term versus permanent employment mix, develop the comprehensive compliance manual, establish the internal audit mechanisms, create the compliance dashboard, monitor the case law developments as per the new law and even the older laws, participate in industry associations for advocacy, and engage with state labor departments for clarifications. Now the important definitions that have changed. First is the definition of wages that has changed. So old definition varied across laws. Payment of wages act plus basic plus DA plus owner say old other remuneration. Minimum wages act included cash plus cash value of corporations, as we know. Payment of bonus act, it included basic plus DA, excluded HRA. Equal remuneration at basic wages. Now under the new definition, that is Code on Wages section 2F, all remuneration expressed in monetary terms. So it includes basic, DA, retaining allowance, and that requires extensive recalculation. So it excludes that is maximum 50% of total bonus, overtime, HRA, conveyance, so special expenses, commission and gratuity, and retrenchment or retirement benefits. So impact is on basic salary must be at least 50% of CTC. That is the basic law. This is what we call as the 50% rule. CTC is cost to company. Worker employee. So old definition, it was varied across 29 laws. New definition, that is harmonized. So code on wages employee is a person employed on wages. Under IR code, it is worker is say it excludes managerial or supervisory, that is earning more than rupees 18,000. Social security code, so includes gig worker and platform worker. Under OSH code, employee, so comprehensive definition including contractual. So you need to redefine complete who is worker, who is employee, and say managerial supervisory staff. So this needs to be done. OSH code, employee, comprehensive definition excluding contractual, and impact is on say wage wider coverage and fewer exclusions. Now the coming to definition of employer. So earlier it was different in each act. New definition is uniform. So person responsible for establishment includes legal representative, managing agent, principal employer is defined for contract labor, and aggregator defined for platform workers. Impact is clear claim of responsibility. So that is the definition of employer. Fourth is the definition of establishment. Old definitions were varied across laws. New definition is excludes it includes all premises, that is shops, factories, offices, covers digital platforms, that is for gig workers, online platforms for gig as well as platform workers. Minimum threshold is 10 to 20 workers depending on code, and state specific say variations may exist. Fixed term employment FT. Old definition was it was not defined. Concept was limited to specific industries. New definition is under IR code section 2 subsection 35. Employment for fixed period as per written contract, specific to say project or seasonal work, that is time bound, and all statutory benefits like permanent employee. So impact is on gratuity after first year, and equal treatment is mandated. Another definition is gig worker, platform worker, and aggregator. So old law, no such say definitions existed. Now the coverage under SS code has been there. So gig worker is defined as under section 235, that is person engaged in or outside traditional employer-employee relationship. So traditional employer-employee relationship is not there, but they are called gig workers, and performs work or services on contractual basis, and contractual they are connected through aggregator or platform, that is online platform. Platform worker are defined in 2 subsection 62. So person engaged through online platform perform certain activities outside traditional employment and may work for multiple platforms. Aggregator is a person who employs, provides them, like say Ola, Uber. So section 2 subsection 5. So digital intermediary or say marketplace, that is included here, like Amazon, e-commerce websites, connects the workers with customers, and examples are say Uber, Swiggy, or say urban company. Impact is that 400 plus 40 crore तो इसे ही बढ़ जाएंगे. So 400 plus million workers now covered under social security under the SS code. Adjudicating authorities. So let us see the appellate structures under the new code. So under the code on wages, claims authorities for say wage claims up to prescribed limit. Appellate authorities for appeals from claims authority. Above that, there is High Court for writ jurisdiction and Supreme Court for appeals under Article 136. For IR code, there is conciliation officers for dispute settlement. वहाँ मामला सॉल्व नहीं होता है तो it goes to industrial tribunal. So for adjudication of disputes, there are no labor courts. So production function is merged with tribunals now. So IR relations के लिए labor courts नहीं है अब. Appellate tribunal proposed, that is 2-member bench. So instead of single presiding officer, there will be 2-member bench, like in case of High Courts or Supreme Court. And High Court for substantial applications, substantial questions of law. उसके ऊपर Supreme Court है. Then code on social security. So EPF or ESIC authorities are there for respective schemes. Above that, there is Social Security Appellate Tribunal that is proposed for appeals. Above that, there will be state or central schemes for respective authorities. They could be notified by state and central governments. High Court and Supreme Court for their constitutional remedies. Under the OSH code, there is inspector cum facilitator. Earlier, it was only inspector. So this is the first level authority. Above that, there is appellate authority for say appeals against the orders of inspector, where they can be challenged. Above that, there is chief inspector for they have supervisory role, and then High Court writ jurisdiction. The jurisdiction and authorities. The key changes are there is single window system. There is one authority for multiple functions. There are time-bound decisions have been prescribed. There is specific limitation timelines have been mandated. Stipulated simplified appeals are there that because there are reduced layers. Digital platforms, that is e-filing, are there. So video conferencing se bhi ho sakta hai. Like in case of say criminal proceeding nowadays, all types of examination, that is examination in chief, re-examination, cross-examination can be conducted online. Similarly here, digital platforms, so e-filing, online hearings, conciliation first, there is emphasis on settlement. Now the limitation periods. This is very important. Code on wages. The wage claims have to be filed within 3 years from date wages become payable. Appeals 30 days from order. That is extendable to 90 days, 60 days. For IR code, disputes within prescribed time under the standing orders. Unfair practices as specified in the rules. So they could differ from state to state. Appeals 60 days from tribunal order. Under the SS code, EPF claims have to be filed within 3 years from code, from date contribution as per the scheme provisions, and appeals will be specified in rules. That is typically 60 days. Under the OSH code, the limitation period will be for prosecution within 6 months of offense, and appeals 30 to 60 days as specified. Specified means specified under rules. Coming to women workers, so special focus on women workers, enhanced rights under the new codes. So equal remuneration, that law, Act of 1976 has been repealed, but the code on wages has become effective in place of that. So section 3, no discrimination in wages on gender grounds. It includes third gender also. No discrimination in recruitment, promotion, transfers. Mandatory equal pay for equal work or work of similar nature. Penalty is imprisonment up to 1 year plus fine up to rupees 50,000. Night shift work, that is governed by the OSH code. So revolutionary change, women can work all shifts in all establishments. Conditions are that express consent of woman is required. Adequate safety measures have to be mandatory by the employer. And imprisonment if transportation arrangements, if the shift ends between 7 p.m. to 6 a.m. So transportation arrangements have to be provided for women. CCTV surveillance should be there, and security engagements. Arrangements. The impact is it opens a higher paying opportunities for women. Maternity benefits. It is under now Social Security Code because the Maternity Benefit Act 1961 has been repealed. So now it is 26 weeks paid leave for first 2 children, 12 weeks for third and subsequent children. Similarly for abortions. Adoption is 12 weeks for adopting mothers. Commissioning mothers, that is 12 weeks. Surrogacy. So now surrogate delivery has also been covered under this. Work from home, that is option for after exhausting leave. So one can be given work from home. That is a new provision. And there is a creche facility mandatory for 50 plus workers, but it could be outsourced also. Protection from sexual harassment. POSH Act remains in force as we have seen earlier. So internal complaints committee is mandatory. External member, so independent woman member required. Fast Act disposal, that is within 90 days timeline, and penalty for non-compliance, say non-constitution of committee. Other provisions include strategic advice for practitioners, for women workers, that is know your rights under the new provisions. Ensure written consent is there for night shifts. Verify safety measures before accepting the night work. Document any discrimination and use strengthened complaint mediations. For employers, comply with the mandatory safety measures. Document the consent procedures. Implement the ICC mechanisms. Provide the transport and security, and budget for maternity benefits, and install the creche facilities if threshold is met. That is more than 50 plus workers. So SS coverage, the extended coverage under Social Security Code. So Employers Provident Fund. So threshold is 20 or more employees. Wage ceiling is 15,000 rupees per month. Contribution is 12% employee, 12% employee. Coverage is all employees including fixed term, FT. Portability, that is a universal account number UN will be there, Aadhaar based. New is gig workers can opt in voluntarily for this. That is for EPF. ESI, older benefits continue. New act has not yet been fully in force, and it will come into force 1 year time is provided. Threshold is 10 or more employees. Wage ceiling is rupees 21,000 per month. Contribution is 3.25% for employer and 0.75% employee. Coverage in medical benefits, cash benefits. The new is voluntary for less than 10 employee establishments. That is a new provision for ESI. Then mandatory for hazardous industries. Even one employee is there, then it is mandatory, and it is extended to all states and union territories. Gratuity. So eligibility is now 1 year of continuous service. That is change from 5 years for fixed term employment. Calculation is 15 days wages into years of service divided by 26. Coverage is all employees including fixed term. Wage definition is as per the new code, 50% of basic rule, as we have seen in the code on wages. Maximum is no ceiling for non-covered establishment, that is rupees 30 lakhs for covered employees. New SS schemes for say unorganized workers. So coming to platform and gig workers, aggregator contribution and capped at 5% of worker payments. Schemes are will be Aadhaar linked. Then for self-employed and unorganized workers, eligibility is all workers not in formal sector. That's why we said that this coverage has been broadened now. The schemes include Pradhan Mantri Shram Yogi Mandhan pension. Then there is this Ayushman Bharat for health and life insurance schemes. So that coverage is extended, and contribution is minimal from worker, plus government subsidy will be given. Building and construction workers, says it is on production. So 1 to 2% of the construction cost. Schemes are education, medical, pension, housing, and registration is mandatory for 90-day workers. So that is for building and construction workers, that is BCW. Then compliance requirements. So for employees, register under the EPF within 1 month of threshold being met. Register under ESI within 15 days. Contribute on or before 15th of next month. File monthly or annual returns online. Maintain digital registers. Display registration certificates and issue UN unified Aadhaar number to all employees and Aadhaar linked number, and separate accounts to FT, fixed term employment gratuity. For workers, obtain the UN or ESIC number, link Aadhaar, verify the contributions, register for voluntary schemes if eligible, and claim your benefits timely and portable across jobs or states. Now penalties and prosecutions, very important part. So code framework under the new codes for penalties is code on wages, major offences, non-payment of wages, penalty fine up to rupees 50,000, repeat offence, imprisonment up to 3 months plus fine up to rupees 1 lakh, cognizable, so can arrest without warrant after second offence, and discrimination, that is gender based, penalty is imprisonment up to 1 year plus fine up to rupees 50,000, serious offence, so criminal prosecution is there. Non-maintenance of records, penalty is fine up to rupees 20,000, and repeat offence fine up to rupees 50,000. For IR code, illegal strikes, penalty is imprisonment up to 1 month plus fine up to rupees 50,000. Applies to workers participating in illegal strike. Illegal lockouts by say employers. So penalty is imprisonment up to 1 month plus fine up to rupees 50,000. Applies to employers declaring illegal lockout. Unfair labor practices. So penalty is imprisonment up to 6 months plus fine up to rupees 1,60,000. And examples are victimization, interference with union activities. I'm concluding in 5 minutes. Closure without notice, that is penalties, compensation to worker plus fine. The third is SS code. So non-payment of contributions, EPF, ESI, penalty is 12% interest per annum plus damages. Criminal prosecution is For say willful default, imprisonment up to 3 years plus fine. For non-registration, penalties fine up to rupees 1 lakh. Back contributions that is payable with interest, and non-maintenance of records, penalties of fine up to rupees 1 lakh. For the fourth code, that is OSH, safety violations. So general violation is fine up to rupees 2 lakh. Fatal accidents, imprisonment up to 2 years to fine up to rupees 5 lakh. Repeat offense, enhanced penalties are there. Employment in hazardous process without license, so penalties imprisonment up to 1 year plus fine up to rupees 5 lakh. Serious offenses, that is license cancellation and non-constitution of safety committees, penalties fine up to rupees 2 lakh. So compounding is possible. So compounding settlement of offense by payment of fine avoids criminal prosecution, available for specified offenses only. Code on wages. So most offenses are compoundable. Authorities, inspector cum facilitator, amount is as specified in rules. In other codes, specific offenses are compoundable. First offense is generally compoundable. Repeat offense, no compounding. Procedure is application to prescribed authority, payment of fine, acknowledgement of violation, order of compounding, and discharge from prosecution. So these are the compounding provisions. So let us stop here. Any questions on this part? Please enlighten us on the Employment Standing Orders Act, and is it valid now too, sir? No, it is completely repealed. But the standing orders remain valid. Okay. Until this, because now under the new act, the standing orders will have to be as per the new code. So this Industrial Employment Standing Orders Act has been completely repealed. But the standing orders issued under the old act continue until renewed, because these orders are valid and now they will have to reissue it under the new code. So the act is repealed now. Okay, only the orders remain valid.
My question is, the current protest by gig workers, they have gone on 25th Jan and again on 1st January they have planned. Now, can they demand compensation or benefits beyond what is declared under the current codes? And number two, if they do, can they force the state governments to enhance the benefits than whatever is declared under the current codes? Over.
Okay. Yes. Well, firstly, since it is a concurrent subject, so many things depend on the state governments also. And as we have seen, the government is treating very cautiously. So it took about 5 to 6 years. All the rules have been prepared because different governments could be there in different states. So firstly, as far as the benefits are there, see new benefits, because this is not, as I have clarified in my previous webinar, it is not a wage revision. Okay. Wage revision happens every 3 months, 6 months. So it is not related to increase or decrease of wages. It is not a commission. It is not a pay commission. It is actually a once in 100 years event. So the benefits are there and they will take long time, because firstly, we have to do comparison of the older benefits as well as the new. And for the pending litigations that are already there, the older laws may be there, and in case of appeals also, we have to see whether it is more beneficial from both sides, because there you could be having clients from worker side, from management side, even from government side, because there could be bipartite or tripartite issues. As far as the extending new benefits is covered, it depends on the new legislation. Okay, because only the parliament can do it. So what has been come into force, it may or may not be sufficient. If they demand something more than that, then that can be done only by the parliament, not by the unions or courts, because that is not possible. As far as the your second question was regarding what was your second question?
Governments,
state governments, yes.
Yeah.
Yes. So state government, as far as the rule making powers are there, that is particularly related to different thresholds or say different relaxations or exemptions to be given. So being a concurrent subject, that depends on state government, and there they can pursue those matters with state government, because as I told, even the state governments are treating cautiously because nobody wants strike, etc. It affects the economy, and therefore whenever these things are there, so there could be legal challenges also. I have not gone much into detail with that, because as far as the labor courts are there, they consider only the matters of fact. If the statutes are to be challenged, then that can be done only at the in the constitutional court, that is High Court, Supreme Court. So rule making powers are still there, and the making governments have to take into consideration that they are not inconsistent with the main or the new labor codes, because if there is something inconsistent, then there could be center state conflicts also. So that those are the things that need to be watched. Otherwise, that could lead to litigation. So as far as the labor unions are concerned, I think it is just a political matter, not legal, because the legal things include the matter pending in labor courts, industrial tribunals, high courts, and Supreme Court only, or the things that are through a legislature, that is in parliament or the state assemblies. So rules have to be laid before the state assemblies, and sometimes it is say conflicts with the center. Sometimes the governor also sends it to the president as per the constitution. So these are the things that need to be considered in case of center-state conflict if it arises.
So as a strategy, the workers, gig workers, they may adopt a strategy of protesting and protesting and protesting until the management itself, going beyond the statute, the current labor codes, the management itself can give them additional benefits or additional compensation in order to avoid impact on the business. As a strategy, they may do this.
Yes, that could be there. See, firstly, it's a new area. Gig workers, platform workers, aggregators. So these are the new employee categories that have been created because of online working. So they have been brought within this labor laws framework now. So first thing is the recognition. So I would say that it is just a beginning. Because firstly, you see, it has to be legalized, because unless you legalize, the government can't tax. So taxation is the main thing for the government. And we know that already the fund and cess laws are already there, but now these have also been brought within the legal framework. So the taxation statutes also apply. They are already there. Direct and indirect taxes are there, because whatever things are done online, so they are also say legal as per the IT Act, Information Technology Act. So these are there. As far as the increased benefits are concerned, so that can be done through demand. As far as the compliance by employer is there, so it is compulsory, because once someone comes in the benefit in the definition of aggregator, then that becomes like an employer, and they will have to comply with this, and they will also have to levy the taxes or deduct taxes at source, and then they have to pay it to the government. So that becomes the duty of all the aggregators, which was not there, because now the social security benefits have been made compulsory. Beyond social security, if they want some other benefits, then maybe they can pursue under the different codes, and maybe they could be notified even by the state governments, because these things, say, evolution of law happens gradually, whether it is within code, within parliament, or whether outside parliament. So all these, because see, we are there is a rule of law, we are all law abiding citizens, and there are all three have their own law making powers, that is the executive, legislature, judiciary. सबका अपना अपना कार्य क्षेत्र है, कार्यपालिका, न्यायपालिका और विधायिका, और वो सब अपना अपना काम करेंगे, एंड लाइक दैट द थिंग्स कुड इवॉल्व इन फर्दर. बट आई वुड से दिस इज जस्ट ए बिगिनिंग. अभी तो शुरुआत हुई है. गीग प्लेटफॉर्म वर्कर्स और एग्रीगेटर को इसमें लाया गया, एंड सी देयर इज सो मच इम्पैक्ट कि 20 करोड़ से 60 करोड़ तक हो गया है द वर्कर्स दैट इज इंक्लूडेड विद इन दिस डेफिनेशन ऑफ वर्कर एम्प्लॉइज, क्योंकि गीग वर्कर, प्लेटफॉर्म वर्कर्स भी आइडेंटिफाई किए गए हैं. सो दिस थिंग्स विल ग्रेजुअली इवॉल्व, and maybe the labor unions or these may pursue these benefits further.
Right. And this may now get extended to the maids at home, right?
Yes. And even they could form their own trade unions. पहले तो पुराना act था trade union at 1926, and they applied to the registrar. Now even these, I think, platform and gig workers could also form their association, क्योंकि ये under constitution ये fundamental right भी है, forming of association. So as you know, in industry वाले भी अपनी association बनाते हैं. So there are associations, there are federations, and there are confederations. मतलब हर industry के भी अपने अपने हैं, and like that they could form their associations. Yes.
No. My last part of question was that this is going to get an inroads into the homemaids also, home maid servants. Slowly this may extend to maid servants.
So the domestic help.
Domestic help.
Domestic help. Yes, that could also be there. Actually क्या है, they don't come within definition of factory as per the law, है ना, तो उसमें नहीं है. और दूसरा, अभी जो definition की गई है कि even some small and medium, because we talk of micro, MSME, micro, small and medium enterprises. So many micro and small industries have been exempted, क्योंकि वो definition retrenchment वगैरह की change कर दिया. So ease of doing business भी ध्यान में रखना पड़ता है, and therefore the government has relaxed them to some extent from compliance. So employers को comply किया गया है, and that's why there could be some resistance by employees union that I can understand.
I think MSME
299 जहाँ पर है, so they have been kept outside the purview of this new labor codes.
मेरा सवाल जरा अलग था. MSME को bypass किया है, अभी benefits दिए हैं, because it is win-win for government, business as well as MSMEs. But what I'm saying is for domestic help, I think it's a big vote bank, and this may get extended to domestic help also. Some kind of codes may come up.
यस, ये भी हो सकता है। सी वर्क प्लेस की डेफिनेशन में तो आ ही गया है। देखो पॉश एक्ट में डोमेस्टिक हेल्प्स आर आल्सो इंक्लूडेड, दे
I
आल्सो गेट द
see.
बेनिफिट अंडर पॉश एक्ट। उनके लिए तो जो घर है वही वर्क प्लेस है उनका, है ना। सो पॉश एक्ट
अच्छा.
हैज ऑलरेडी बीन एक्सटेंडेड टू देम। सो उसी तरह से ये जो इसका लिबरल इंटरप्रिटेशन होता है, तो वर्क प्लेस और इसमें जो है एम्प्लॉयर एम्प्लॉय की डेफिनेशन में अभी उसको नहीं माना गया, बट कंपलसरी जो एम्प्लॉय अपॉइंटमेंट ऑर्डर कर दिया गया है, दिस इज गोइंग टू
हाँ.
अफेक्ट सो मेनी पीपल। इसलिए मैंने बोला कवरेज बढ़ने वाला है, हर एक को अपॉइंटमेंट लेटर देना पड़ेगा। सो ये प्लेटफॉर्म गीग वर्कर्स के लिए भी जरूरी होगा। ऑफ कोर्स वो ई अपॉइंटमेंट लेटर हो सकता है थ्रू द प्लेटफॉर्म, वैसे मिल सकता है। डोमेस्टिक हेल्प विल आल्सो गेट देयर, आउटसोर्स वाले एम्प्लॉय भी मिलेंगे। कॉन्ट्रैक्ट लेबर रेगुलेशन एक्ट अबॉलिश हो गया, लेकिन जो एफटी नया रिकॉग्निशन कर दिया फिक्स टर्म एम्प्लॉयमेंट, सो फिक्स टर्म एम्प्लॉयमेंट है तब भी अपॉइंटमेंट लेटर देना मैंडेटरी है। सो ये चीजें हो गई है, एंड दैट इज गोइंग टू एक्सटेंड द बेनिफिट्स, और बहुत सारे लोग इस कैटेगरी में आ जाएंगे।
Oh,
सो
thank you,
योर
thank
क्वेश्चन
you.
इज वेरी वैलिड वन, एंड दीज आर एक्चुअली द क्वेश्चन फॉर एडवोकेट्स की यही सब चीजों पर तो विचार करना है और एडवाइस देना है, बिकॉज ऑफ ये डिफरेंट टाइप्स ऑफ डेफिनेशंस। तो फिर एम्प्लॉयर की डेफिनेशन, वर्कर की डेफिनेशन, ये सब देखना पड़ेगा कि उसमें वो आता है नहीं आता है ना। दीज आर द
Right,
न्यू आई कैन से चैलेंजेस एज वेल एज अपॉर्चुनिटीज फॉर अस।
right, right. And thank you very much for the studied inputs for us. Thank you very much.
Sir, one question in the registration form: which state, according to you, is actively implementing the act and doing it in a speedy manner?
Okay, act of implementation of the code,
Yes, sir.
which date? Yes, yes. See, actually, I have not got into that implementation timeline. But some, चूंकि एक्ट तो 2019-20 में ही पास हो गए थे चारों, तो some parts were already implemented. जैसे कि सेंट्रल एडवाइजरी बोर्ड भी ये पहले बन गया था 2020 में ही। दे आर ऑलरेडी देयर ऑन द मोल वेबसाइट, तो वो आपको मिनिस्ट्री की वेबसाइट पे मिल जाएगा। उसी तरह से कुछ सुप्रीम कोर्ट के जजमेंट की वजह से सब प्रोविजंस रिलेटेड टू ईपीएफ एंड ईएसआई वेर ऑल्सो ऑलरेडी बीन इम्प्लीमेंटेड। और इसीलिए आप देखिए जो अभी 25 नवंबर के जो गैजेट नोटिफिकेशन आए हैं 25 नवंबर 2025, सॉरी 21 नवंबर, तो उसमें ये आया है कि सम सेक्शंस हैव बीन एक्सक्लूडेड। इसका मतलब ये नहीं है कि वो इम्प्लीमेंट नहीं हुए। सम ऑफ देम हैव ऑलरेडी बीन इम्प्लीमेंटेड और वेयर ऑलरेडी इम्प्लीमेंटेड, एंड सम प्रोविजंस विल बी इम्प्लीमेंटेड ओवर नेक्स्ट 1 ईयर। जो मैंने बताया कि पर्टिकुलरली ईपीएफ एंड ईएसआई, वो इसलिए कि किसी का नुकसान नहीं होना चाहिए। जो बेनिफिट्स चल रहे हैं पिछले, उसमें कंटिन्यूटी रहनी चाहिए फॉर वर्कर्स। So to ensure the continuity of the benefits that were already given, किसी का भी बेनिफिट इसमें कम नहीं हुआ है, बेनिफिट तो बढ़े ही है। एंड देयरफॉर दिस फॉर कंटिन्यूटी पर्पस, ये जो इम्प्लीमेंटेशन टाइमलाइन है इस पर भी मैंने एक स्पेशली अलग से एक प्रेजेंटेशन बनाया है, बट मे बी वी कैन हैव दैट इन द नेक्स्ट वन। तो उसमें फिर ये और डिटेल में हम जा सकते हैं। आई हैव नॉट गॉन सेक्शन वाइज और से सब सेक्शन वाइज की क्या क्या इंप्लीमेंट हुआ है, क्या नहीं हुआ है, क्या रिपील हुआ है, क्या नहीं हुआ है, बट ब्रॉडली मैंने 2 एरिया बता दिए, ईपीएफ एंड ईएसआई। सो ये जो 2 चीजें हैं इसमें अभी भी चीजें बाकी है। बाकी जो अदरवाइज है सब चीजों में 21 नवंबर 2025 विल बी द इफेक्टिव डेट एज पर एज द स्टेट रूल्स आर देयर। सो दे हैव सम लिबर्टीज, और कौन सा कब रिपील होगा या बिकॉज सबऑर्डिनेट लेजिस्लेशंस आर ऑल कंटिन्यूइंग, वो तो सब रूल्स रेगुलेशंस नोटिफिकेशंस गवर्नमेंट ऑर्डर्स एंड ऑफिस ऑर्डर्स ऑल आर वैलिड। तो जितने भी सबऑर्डिनेट लेजिस्लेशन है वो सब कंटिन्यू रखे गए, क्योंकि दे विल फॉलो द लाइंस ऑफ द कोड। तो पहले तो कोड को रिपील किया है, अब इसके बाद जो सबऑर्डिनेट लेजिस्लेशन है वो धीरे धीरे चेंज होगा। एंड डिपेंडिंग ऑन हु यू आर, दैट इज वेदर यू आर एडवोकेट, वेदर यू आर फैक्ट्री वेलफेयर ऑफिसर, स्टेट गवर्नमेंट आपको अपने डेप्यूटी लेबर कमिश्नर, सेंट्रल लेबर कमिश्नर, वहां से जो नोटिफिकेशन और ये जो आते रहेंगे और पब्लिश होते रहेंगे, दे विल बी अवेलेबल ऑन द स्टेट वेबसाइट्स ऑल्सो, तो दैट यू विल हैव टू मॉनिटर। वहां से आपको एक्जैक्टली पता चलेगा कि क्या क्या चीजें लागू हुई है और कौन कौन से रूल्स रेगुलेशंस रजिस्टर फॉर्म्स वगैरह, यू कैन गो अप टू दैट डिटेल। तो ये सब जरूरी है, एंड दैट इज आई थिंक ए हॉट एरिया फॉर ऑल प्रैक्टिसिंग एडवोकेट्स, क्योंकि इसमें क्लाइंट्स को एडवाइस करना पड़ेगा। बिल्कुल, यस।
जी sir. Sir, last question. Registration form say which sector, according to you, is the most ignored in the new codes?
मोस्ट
Very
इग्नोर्ड,
generic question. हाँ, कोई sector you think is ignored?
इग्नोर्ड तो ऐसा नहीं है, क्योंकि देखो जो इग्नोर्ड जिसको हम मानते हैं वो होता है अनऑर्गेनाइज, और चूंकि अनऑर्गेनाइज सेक्टर के लिए भी ऑलरेडी कानून पहले भी थे और अभी भी है। सो जो भी जनरल इसमें नहीं आता है, फॉर एग्जांपल हमने सिने इंडस्ट्री देखा, जर्नलिस्ट देखा, बीड़ी एंड सिगरेट वर्कर्स देखा, या फिर हमने ये है अलग अलग टाइप के सेस, और ये वेलफेयर फंड वेलफेयर सेस है, ये सब ऑर्गेनाइज है और इसीलिए इतने सारे कानून है। अब जो कवर नहीं होते उनके लिए अनऑर्गेनाइज सेक्टर्स है, जैसे बिल्डिंग एंड कंस्ट्रक्शन वर्कर्स रह गए थे, उसके लिए कानून अलग से बन गया, दूसरे भी बन गए। सो जहां जहां पर रह गए, सो ये जो अनऑर्गेनाइज वर्कर्स के लिए भी एसएस बेनिफिट्स और ये एक्सटेंड कर दिया गया है। तो दैट विल सिग्निफिकेंटली इम्प्रूव। अब कौन नहीं आता है वो तो फिर इसमें देखना पड़ेगा, बट आई थिंक कवरेज बहुत ज्यादा वाइड हो गया है, और ये जो सीधा 20 करोड़ से 60 करोड़ जो कवरेज हो गया है, दैट इटसेल्फ इज गोइंग टू बी अ बिग चैलेंज फॉर एम्प्लॉयर्स एज वेल एज द एम्प्लॉयज, क्योंकि एम्प्लॉयज को भी अवेयरनेस धीरे धीरे बढ़ानी पड़ेगी कि क्या इसमें मिल रहा है, क्या बेनिफिट इसमें हो रहा है, और क्या क्या बेनिफिट इसमें आए जा सकते हैं, एंड ग्रेजुअली द थिंग्स विल इवॉल्व। और फिर बहुत सारी चीजें, ई श्रम, ई सुविधा, ये जो पोर्टल्स है, इस पर भी गवर्नमेंट ने किया है। सो इवन द मोबाइल एप्स आर नाउ अवेलेबल। जैसे पहले हमने देखा ना कि एनसीआरबी के क्रिमिनल लॉ अवेलेबल है एनसीआरबी संकलन वेबसाइट पर, तो उसमें नेशनल क्राइम रिकॉर्ड्स ब्यूरो में आपको ओल्ड और क्रिमिनल लॉ के टेबल्स मिल जाते हैं, है ना, कि आईपीसी वर्सेस बीएनएस या सीआरपीसी वर्सेस बीएनएसएस या इंडियन एविडेंस एक्ट वर्सेस भारतीय साक्ष्य अधिनियम। तो वैसा ही इसमें भी जो है करस्पॉन्डिंग बहुत सारी चीजें श्रम सुविधा पोर्टल और इस पर भी नोटिफिकेशंस वगैरह आते जाएंगे, एंड वन नीड्स टू कंटिन्यूअसली वॉचिंग देम फॉर मोर एंड मोर अपडेट्स, बिकॉज चलते आ रहा है। एक महीने में बहुत सारे अपडेट्स आ गए जो आज मैंने कवर नहीं किया, बट पिछले एक महीने में भी आफ्टर 21 नवंबर देयर हैज बीन अ फ्लड ऑफ नोटिफिकेशंस ऑन से कुछ तो मेरे ईमेल में भी बहुत सारी चीजें आ रही है। Even I don't have time to read all these things. तो ये सब चीजें मॉनिटर करनी पड़ेंगी, and these things have to say we have to keep updated so that we don't become obsolete and remain relevant. तो ये expertise और knowledge तो सबको develop करना पड़ेगा, whether you are labor court advocate or not, even for law students, क्योंकि उनको तो नए पुराने दोनों कानून की जरूरत पड़ेगी। Once you become advocate, आपके पास केस किसी भी स्टेज का आ सकता है। इट कुड बी ओल्ड लॉ, इट कुड बी न्यू लॉ। तो फिर आपको पहले तो स्टेज समझनी होगी कि ये क्या पुराना डिस्प्यूट है, क्या एपेलेट स्टेज पे है, क्या रिविजनल स्टेज पे है, कौन से स्टेज पे है, एंड आफ्टर अंडरस्टैंडिंग दैट वी हैव टू एडवाइज द क्लाइंट्स अकॉर्डिंगली।
Agreed, sir.
There's a professional tax. Yes, taxation law तो वही चलेगा, हाँ, but there is one important change. Income Tax Act has been repealed, और रिपील होगा मतलब 1 अप्रैल 2026. So Income Tax Act 2025 has been passed by the Parliament, and that will come into effect from 1st April, the new financial year. तो इसलिए जो प्रोफेशनल टैक्स है, जो वो पूरा सब कुछ चेंज होने वाला है। सो मे बी वी कैन हैव वन फुल वेबिनार ऑन दैट इनकम टैक्स एक्ट। तो उसमें फिर हम आईटी एक्ट और ये प्रोफेशनल टैक्स वगैरह का डिस्कस करेंगे। ओके, अभी तो टैक्सेशन लॉ जो है रिपील हो गया है, बट मैंने बताया इफेक्ट में आया नहीं है, इफेक्ट में आएगा 1 अप्रैल से,
Yes, sir.
है ना।
Yes, sir.
हाँ, तो वी नीड टू मॉनिटर दैट आल्सो, एंड दैट विल, क्योंकि टैक्सेशन लॉ तो अपने आप में बहुत बड़ा सब्जेक्ट है। इनफैक्ट जो टैक्सेशन प्रैक्टिस करता हो तो टैक्सेशन के अलावा कुछ करता ही नहीं, क्योंकि बाकी एक्ट में तो ऐसा है कि नया एक्ट आ गया, पुराना एक्ट भूल जाओ। टैक्सेशन में तो ऐसा नहीं होता, उसमें ये देखना पड़ता कौन से साल में कौन सा टैक्स था, तो वो पुराने सब कानून है वो भी याद रखने पड़ते हैं। सो देयर हैज टू बी एलिफेंटाइन मेमोरी फॉर टैक्सेशन लॉयर्स। इसलिए वो जो टैक्सेशन करता है वो भी टैक्सेशन तक ही रिस्ट्रिक्ट रह जाता है, उससे ज्यादा वो आगे मतलब उसके ज्यादा करना भी नहीं पड़ता है, क्योंकि टैक्सेशन इटसेल्फ इज ए वेरी वास्ट फील्ड। तो टैक्सेशन
Yes,
में
sir.
स्पेशलाइजेशन है तो फिर वो टैक्सेशन लॉ अपने आप में एक बहुत बड़ा फील्ड हो जाता है।
As we spoke about unorganized sectors, something like agricultural sector where there are a lot of laborers engaged in the fields, are there any what do you call it remedies for them, the new codes?
यस, न्यू कोड्स में एज फार एज हैजार्डस इंडस्ट्रीज है तो वहां तो कवर्ड है, इवन इफ देयर इज सिंगल वर्कर। और बाकी जगह पर जो है तो अनऑर्गेनाइज वर्कर्स एक्ट जो है या उसके जो करस्पॉन्डिंग सेक्शन है अंडर द न्यू कोड्स दे अप्लाई। तो इसलिए वो जो ऑलरेडी कवरेज है वो तो है ही, केवल एक ही डेफिनेशन जो है उससे बहुत सिग्निफिकेंट चेंज हुआ है। और ये देखना पड़ेगा कि वेदर दे कम अंडर डेफिनेशन ऑफ वर्कर और एम्प्लॉय, जो न्यू डेफिनेशन है, और अंडर प्लेटफॉर्म और गीग वर्कर और एग्रीगेटर, तो एम्प्लॉयर एम्प्लॉय या एस्टैब्लिशमेंट। तो ये जो डेफिनेशन है ये इसी में फंडामेंटल चेंज हो गया है, और इसकी वजह से बहुत चेंजेस होंगे। सो दीज हैव टू से वॉच क्लोजली। तो इसमें आपको पुरानी और नई डेफिनेशन दोनों पढ़नी पड़ेंगी, एंड यू विल हैव टू मेक कंपैरेटिव एनालिसिस कि इसमें कौन कौन है वो कवर होते हैं नहीं होते हैं। तो अनऑर्गेनाइज के भी बहुत सारे आ रहे हैं, जैसे कि ये डिजिटल और ऑनलाइन सब अनऑर्गेनाइज ही तो था। अब गीग और प्लेटफॉर्म वर्कर्स कर लिया तो ऑनलाइन एम्प्लॉयमेंट इज इंक्लूडेड। डोमेस्टिक हेल्प का जैसे क्वेश्चन हुआ, अनऑर्गेनाइज के लिए अलग से भी एक्ट है। तो अब एसएस बेनिफिट जो है, सोशल सिक्योरिटी बेनिफिट, तो बहुत सारे लोगों को लागू हो जाएंगे। तो इसलिए वो हमको देखना पड़ेगा। बाकी जो अदर चीजें है कि यूनियन वाला है, आईआर है, या फिर जो वेजेस है, क्योंकि वेजेस की भी डेफिनेशन फंडामेंटली चेंज हो गई है, 50% रूल आ गया है। तो इसे इनिशियली है कि कॉम्प्लायंस बर्डन इनका बढ़ जाएगा, बट अल्टीमेटली एम्प्लॉयर्स विल आल्सो बेनिफिट, क्योंकि वो सिंगल रजिस्ट्रेशन और फिर ये इंस्पेक्टर राज खत्म करके जो इंस्पेक्टर कम फैसिलिटेटर बनाया गया, तो इसे मुझे लगता है कि काफी करप्शन वगैरह भी कम हो जाएगा। सो दीज आर सम बेनिफिट्स दैट क्रिमिनल लॉ में हमने देखा था कि पार्लियामेंट में अमित शाह जी ने बोला था कि कन्विक्शन रेट हैज टू बी इंक्रीज फ्रॉम 10 to 90%। और पुलिस और जजेस को चेंज करना बहुत डिफिकल्ट है, और वो 160 साल बाद ये प्रयास हुआ है, तो धीरे धीरे हो रहा है। और अभी उन्होंने बोला 2027 तक हो जाएगा, और ये हो जाएगा तो अरेस्ट और बेल के प्रोविजन भी सब ऑब्सोलेट हो जाएंगे, देखना। फिर वीडियो कॉन्फ्रेंसिंग से अपीयर हो सकते जज के सामने, वकील तक आजकल कोर्ट में जाते नहीं। आपने देखा कॉन्स्टिट्यूशनल बेंच 9 जज की बेंच के सामने भी वकील नहीं जाते, घर में बैठे बैठे अपीयर हो रहे हैं। तो उसमें वो रिस्ट्रिक्शंस है, एंड देयर आर रूल्स, वीडियो कॉन्फ्रेंसिंग ये वो सब चीजें हैं, बट दे हैव इम्प्लीमेंटेड। तो ये चीजें धीरे धीरे होने वाली है। तो फिर अरेस्ट और ये समन्स और वारंट और बेल और बहुत सारी चीजें जो है दे आर गोइंग टू बी रिडंडेंट, धीरे धीरे चीजें ऑब्सोलेट हो जाएंगी, देखना। बस ये होगा कि समन्स वारंट है, ईमेल है, व्हाट्सएप है, रिप्लाई करो, नहीं है तो पुलिस दरवाजे पे आके खड़ी हो जाएगी। तो पुरानी चीजें तो रहेगी, बट ये सब चीजें जो है बहुत ऑब्सोलेट हो जाएगी। दीज आर गोइंग टू हैपन। और फिर क्रिमिनल लॉज के लिए आया है, होम मिनिस्टर बोल रहे हैं कि 2027 तक पूरा हो जाएगा इम्प्लीमेंट। तो एक बार कंप्यूटर आ गए तो फिर क्रिमिनल कोड वाले यूज करें तो सिविल कोड वाले भी यूज करेंगे, तो चेंज तो होना ही होना है। फिर लेबर कोड, फैमिली कोड, सभी जगह पर हो जाएगा ये इस तरह से। ऑलरेडी इंफॉर्मेशन कमीशन के लिए ऑलरेडी किशन चंद जैन केस में सुप्रीम कोर्ट ने बोला है, हाई कोर्ट के लिए और सुप्रीम कोर्ट के लिए वीडियो कॉन्फ्रेंसिंग कर दिया है। तो उस तरह से कोर्ट ने ऑलरेडी बोला है, सुप्रीम कोर्ट ने, सीजेआई चंद्रचूड़ साहब ने बोला था कि ये सिर्फ एक बार कोविड के लिए खर्चा नहीं किया करोड़ों रुपए का, यार ये आ गया है, यू हैव टू यूज देम,
Yes, sir.
पर्टिकुलरली दो पीपल हु आर यंग, है ना, तो यंग जजेस, सो दे शुड यूज। और ये धीरे धीरे हो भी रहा है, बिकॉज पूरा वो जनरेशन डिफरेंस है ना। अब तो मोबाइल जनरेशन के लोग आ गए, जेन जेड जिसको हम बोल रहे हैं, जेन जी। सो वो बच्चे हैं जो पैदा होती है जिन्होंने मोबाइल फोन देखा। सो देयर हैज टू बी सिग्निफिकेंट चेंज, ये धीरे धीरे चेंज हो रहा है। और जुडिशियरी में भी चेंज आएगा। और एआई यदि यूज होता है तो ये भी हो सकता है कि ये जो करोड़ों की पेंडेंसी है, 5 करोड़ से ज्यादा केसेस, सो दिस कुड बी रिजॉल्व बाय एआई, ये भी हो सकता है। इट्स ए फ्लरिशिंग एरिया, इस पर भी हम कर सकते हैं वेबिनार।
Yes, sir. Thank you, sir. Bye, sir.
Thank you. Thanks for inviting me. Thanks to all the participants. Bye.